Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about the court ordering lawyers to act. Cases that should have gone to the Supreme Court of Canada, but didn't. There are certain circumstances in which a court can order somebody to act as counsel for an individual. This case involved that situation. In a class action for the vaccine lawsuit, a case that was brought by a couple parties was dismissed by the counsel for that individual filing a notice of discontinuance. After the discontinuance was filed, the individuals whose claims were discontinued from the court applied to the court to have their claims reinstated, arguing that they didn't consent to having the cases discontinued, notwithstanding the actions that their lawyer took. The court ordered that their matters be reinstated on the court list and that the discontinuance be canceled, and ordered that the lawyer who filed the notice of discontinuance continue to act for those individuals. The lawyer disputed this, indicating that they were essentially in an ethical quandary where their instructions and their ability to receive instructions from their client was compromised because of the communication issues. The court nevertheless required the lawyer to act. The Supreme Court of Canada was faced with a very important question here, which is circumstances in which a lawyer is required to continue to act where they assert that there is some sort of an ethical or professional conflict that prevents them from doing so. In the previous Supreme Court of Canada case dealing with the obligation of a lawyer to continue as counsel, Cunningham, the court considered only this in the context of a non-payment of legal fees. But there are other situations in which a lawyer can no longer act for somebody, and there are rules governing the ethics of lawyers that prevent a lawyer from acting for somebody in certain circumstances. The Cunningham decision seemed to suggest that if a lawyer asserts that that's the situation and they can no longer act for the person because of ethical boundaries, that should be accepted on its face. Yet the court didn't accept it here. So the Supreme Court of Canada had an opportunity to clarify what happens in circumstances where the lawyer is asserting there's an ethical issue, but where there's a dispute about whether there is in fact an ethical issue and the court doesn't accept that. What tests should the court apply to determine whether or not there is truly an ethical issue, or whether this is motivated by some other illegitimate reason for getting off the record? This is an important issue for the Supreme Court of Canada to decide on, because lawyers remove themselves from cases across this country hundreds of times every year because of ethical conflicts or professional issues that arise with their clients. And to give lawyers across the country guidance on what standards they should be applying, as well as giving law societies guidance on how their professional rules of conduct should also govern lawyers in the context of the way the Supreme Court of Canada has interpreted this issue, would be an important thing. Unfortunately now, there is none of this guidance from the court, which means we're left in a situation where there are all these unanswered questions about the power and the extent of the power that judges have to order a lawyer to continue to act for somebody where they say it would be unethical to do so. Hopefully the Supreme Court of Canada recognizes that this does need to be an issue that has federal guidance from the top court in the country, that this is a matter of national importance, but it will take another case before that happens. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.